Good afternoon, everyone. Welcome back. Firstly, a big thank you to Darlene and the panelists of Panel 1 for not just reflecting on the historical evolution of international criminal law, but also showing us how historical interactions and fault lines continue to have an enduring impact on the present. At some point in the panel, I think we heard the phrase, the internalization of norms, and Panel 2 will now see how that has worked out in practice. So I would like to introduce the moderator of our panel, Philipp Graebke, who is a research associate here at the Friedrich-Alexander-Universität of Erlangen-Nürnberg and previously worked with the independent commission on examination of the history of the Federal Ministry of Justice here in Germany. I'd like to hand over to you now. Thank you.
Well, thank you, Kiran, and good morning from my side to everybody. It's very nice to be able to welcome you here to Panel 2. We are going to look at lessons from the domestic experience for the next 90 minutes. I also have prepared a nice text that I wanted to read you. The problem is, however, Professor Simpson has, in his first statement, basically said everything I wanted to say, so I'll just paraphrase. We started out with ICL here in Nuremberg on the international level, but after Tokyo, basically, this international avenue ended, at least temporarily. And we were thrown back to use something that we often consider now as sort of a second-tier avenue, the domestic proceedings, the domestic prosecution of international crimes. We actually had thousands of cases under national law in various forms, World War II related, while due to the Cold War and other reasons, there was not really much going on the international level. So when we discuss this today, we should sort of keep in mind that this is actually a powerful tool in order to get international justice done. And in the current political climate that's often hostile towards ICL and human rights, maybe this is also an avenue we can look at closer again and increasingly use again in order to further our aims. So we wanted to go through this topic, touching on three areas. One, just sort of an assessment. What have national proceedings so far done for us? What are cases of success? What are examples for failure or at least sluggish process? And what can we change in order to facilitate this further? Secondly, we want to have a look at education. ICL courses in uni are often non-existent or they are very short. Criminal law education is very much focused on domestic crimes, which is what most practitioners also work on. So even when somebody gets in contact with ICL the first time, they often are already a working practitioner. So often their only education on ICL matters is sort of post-university courses, classes, and we want to have a look into what is being done there at the moment and what we could do to improve on those. And thirdly, we would like to look at how to operationalize complementarity, what improvements can be made in the division of labor, in the sharing of information, how to make this complementarity system work or work a little better in case we find that it already does work. So this will go on for about 90 minutes, this panel. For the first 60 minutes, we'll have the discussion of the panelists here. The last 30 are reserved for questions. However, if you would like, you can already use this QR code here on the back of the brochure and already post questions. Then the panelists can see them here and already sort of group them and then see that later maybe we can answer one or two more if we are a bit more efficient on this. So, let me quickly introduce our speakers. and then I'll hand over the word. First of all, this is Professor Leila Sadat. She's the James Carr Professor of International Criminal Law at Washington University in St. Louis. She is a former special advisor on the crimes against humanity to the ICC Prosecutor, and she is the chair of the steering committee of the Crimes Against Humanity Initiative, a thing that she will surely talk about, a very important ongoing development. To her right, we have Professor René Urueña, if that is halfway correct. He is a professor at the Universidad de los Andes in Bogota, and he served as an advisor to the selection committee of the special jurisdiction mechanism for peace in Colombia, and I'm very curious what he can tell us about this. So then here to my left, we have Judge Ute Hohoff, who is a judge as a federal judge here in Germany at the Federal Court of Justice in the Third Senate, which deals with appeals in ICL cases, amongst other things. And we have the director of the Siracusa Institute, Mr. Jean-François Thony, hopefully also pronunciation halfway correct, who used to be a prosecutor general in France, I believe in Rennes and in Colmar, and who used to be head of the École de la Magistrature, and therefore hopefully will also tell us a bit about his experience and perspective on this educational theme. So, thank you very much, and I would like to hand the word over to you, Professor Sadat, and you can start.
Thank you so much, Philip, and thank you for the invitation to be here. It's always a little intimidating to speak in courtroom 600 because of the historical weight of the space itself, as well as the erudite quality of all of the listeners here. But I will endeavor to try to add something to the conversation that's already been very rich and really quite extraordinary over the past 2 days. I am a non-compliant panelist because I told Philip I actually wanted to talk about something slightly different, and he's allowing me to do that. But what I wanted to say is I wanted to frame the conversation about domestic crimes and domestic systems and accountability a little bit differently, and maybe to give an overarching framework that then I think we can fit in the very interesting questions that Philip has for us. When we think of domestic systems and accountability for international crimes, there are two categories, and we heard about some of them yesterday and today. One is the transitional justice category, right? One is the, we heard Christoph Safferling talk about we need a new Nuremberg moment, and many domestic jurisdictions have had mini Nuremberg moments, such as the 1985 junta trials that President Hernández talked about yesterday, and so that was very, very interesting. And so sometimes we have transitional justice happening within a national system. Sometimes the national systems are exercising universal jurisdiction. So in a sense, they're sitting as agents of the international community. That's how the French Cour de Cassation, the Chambre criminelle, talked about the Barbie case, that the French courts were actually sitting as agents of the international system in trying a case under universal jurisdiction. And the success and failure of these two different models is going to be quite different. And the interests of the state in pursuing these different models is going to be quite different. So in the transitional justice framework, which is sort of how I parachuted into this field, was with the Touvier case, actually, in France, where there was a Vichy collaborator who was rediscovered some decades after the commission of the crimes that he was alleged to have committed during World War II. And what I learned from a deep study of that case is, first lesson is the victim's desire for justice continues unabated over time, over space. They are relentless in their desire, in the transitional justice space especially, to see the harm that happened to them and their families acknowledged and justice delivered. And so that is one, I think, takeaway, is the victims don't forget. The state forgets. The population forgets, but the individual harm, these are mass atrocities, but we forget that they afflicted the lives of individual human beings. And they don't forget, and they want justice. And they spoke very movingly in the trials in France, the first trials that I studied in the transitional justice space, really. They spoke very movingly about how they felt silenced for decades until all of a sudden there was a court where they could tell their story, and they felt like they had come alive. The other lesson we have is that the local power structures will always resist. They will always resist the desire for justice. And one of the things that we see is even in the national systems, the justice versus peace debate happens. Again, thinking of those transitional justice, oh my goodness, we have to let sleeping dogs lie. We'll have a revolution. We'll have an outbreak of conflict. We'll have riots if we dig up this past. We heard that in the Vichy context. I'm sure you heard it in the context of the junta. We can't go there because that would be too scary. It would roil our country. And in fact, it is true that in the transitional justice space, it's often decades before you can start to bring the cases because the power structures have resisted and it's very challenging to do it. But once that opening happens, in fact, there's a flowering that happens. The threats that there would be civil, degradation in France if we actually unearthed the Vichy past turned out to be completely untrue. And it opened a new space for an apology for the anti-Semitism of the Vichy regime. And I think the same thing has been true in Argentina and in many, many other countries. So this idea that peace versus justice, I think it's a shibboleth. I think it's a shibboleth at the national system, and I think it's not true internationally either. Timing matters because political space has to open. That's true. But in terms of the either or, there has to be both, or you can never move. And I see that in my own country, for example. And my third takeaway is an absence of justice leads to impunity, and that impunity will fuel more injustice. And here I'm going to use my own country. We engaged in a crime known as torture during 2003-2004, which was an explicit 2001, 2002, 2003, which was an explicit policy of a U.S. presidential regime. And I've said this in the United States. I'm not just saying it because I'm abroad. And that torture, unfortunately, was never prosecuted. And what we have seen is, because now 2 decades have passed, is that we see a resurgence of criminality. We just heard our Secretary of Defense argue that we have to loosen the laws of war, which was exactly the argument we heard in 2002, 2003. And so we see that if there is no justice in these cases, you will indeed, as predicted and as experienced, you will fuel a cycle of impunity. And the impunity will grow and the crimes will potentially grow. And so bringing justice to the situation is incredibly important. And finally, I wanted to say, and these are all really in the transitional justice space. The universal justice space is a little different because there we have had many challenges, and maybe we'll talk about that in a second round, because when you're prosecuting individuals from other countries who have somehow come to your country, either they've sought refuge there, or in the United States, we don't actually use the core crimes to do a lot of this work. We use trafficking, drug trafficking, narcotics trafficking, terrorism, and I think France does the same thing, actually. You'll see the transnational criminal statutes used to grab people for crimes that you might have thought were core crimes. In that kind of space, it's a very different situation because the national system's not resisting the application of justice, but justice can be challenging to deliver because you're far away from the scene of the crime, the evidence is challenging, victims may not be able to appear. So universal justice is there as a backstop, but it's never completely ideal, although it can be incredibly important. And the Pinochet moment, I think, was a huge moment. I think in France now we have the Assad moment, which is a huge moment. So finally, my last thought is this is why we need to shore up national systems. I remember when Sharif was alive, those of us, I have to always say Sharif's name when I talk about crimes against humanity or the Crimes Against Humanity Treaty, because of course I had the privilege of working with him for so many years, and he was in a way our father, right? I see Bill there, he was our father. But he would always say the beast of impunity, it's like Gulliver and the Lilliputians. And we're like the Lilliputians, and Gulliver is impunity. And we're trying to use all our strings to to tie down the beast of impunity. And that's why the national systems are so important. Crimes against humanity, the new treaty, which maybe we'll talk about in the Q&A, is such a key part of this, because crimes against humanity can happen in peacetime, they can happen in wartime. It applies to state and non-state actors. It can cover a whole range of 11 different offenses, including other inhumane acts, which can scoop up things like starvation of a civilian population or forced marriage. And so having this gap, I know that Eleanor Hammarskjöld referred to this in her opening remarks. It's been a huge gap, and I've been really honored to lead this campaign for a new treaty for 17 years, to try to fill this gap in international criminal law, because we need the addition of this additional core crime. So I think I'll stop there, Philip. I haven't really answered your questions, but I hope it's been a useful, intervention nonetheless.
Oh, I'll ask you again, and it's about the conversation. So I think that was a very good start indeed. Thank you very much for that. With a bit more of a more concrete question to Judge Hohoff, would you like to tell us a bit about the current German situation? Germany has enacted a code of international crimes a while ago, and you could say a lot has happened. What is currently the situation? We'll then hear later about the situation in France and the rest of the world, and then we get an impression of how it's standing at the moment.
Thank you. First of all, I would like to thank for the invitation to this event, and I'm honored to be part of this distinguished panel today. So it's important to mention that although the Code of Crimes Against International Law was adopted in Germany in 2002, it took some years before German prosecutors and courts began to apply international criminal law. However, they have now fully accepted their responsibility, and the courts have been successful in prosecuting international crimes. To begin, the first trial came before Stuttgart Higher Regional Court in 2011. The underlying case pertained to crimes committed in the FDLR, Force Démocratique de Libération du Rwanda, in the provinces in North and South Kivu in the DRC. Following this, the Federal Public Prosecutor General, it's an horrible word, but it's the name, the Federal Public Prosecutor General of Germany initiated the prosecution of several perpetrators. Most of the investigation pertained to Syria or Iraq and crimes committed by the Islamic State and representatives of the Syrian regime. I will now present some important examples of past decisions of the Federal Court of Justice and the higher regional courts. Perhaps I have to explain the higher regional courts in these cases are the first instance, the fact-finding instance, and the Federal Court of Justice is the Court of Appeal. And the Federal Court of Justice is also involved in the investigating phase. We are responsible for pre-trial detention decisions. Two decisions of 2022 and 2023 pertain to the genocide of the Yazidi population. The first decision concerned the appeal of an Iraqi against a November 2021 decision by Frankfurt Higher Regional Court. The court convicted the accused, an Iraqi member of the Islamic State, inter alia of genocide and a crime against humanity which resulted in death. Frankfurt Higher Regional Court imposed a life sentence. It qualified the assault on the Yazidis in Iraq in and after August 2014 as genocide pursuant to the German Code of Crimes Against International Law. The underlying facts are the accused and his German wife held a Yazidi woman and her 5-year-old daughter as slaves in their household in Fallujah in Iraq. The accused regularly beat them. In August 2015, he tied the girl outside the house, exposing her to such extreme heat and direct sunlight that she eventually died. On appeal, the court, confirmed the conviction based on the crime of genocide and the life sentence of the Iraqi man. The German woman was convicted by Munich Higher Regional Court of inter alia assisting to an attempt of murder committed by omission and a crime against humanity resulting in death. After an appeal of the Federal Public Prosecutor General of Germany, she received a joint sentence of 14 years. In January 2021, a verdict delivered by the Federal Court of Justice concerning functional immunity of a lieutenant of the Afghan army was a fundamental and significant decision. The underlying facts are as follows. The accused and a deputy commander of a military base in Afghanistan tortured as joint perpetrators 3 Taliban prisoners in order to obtain information on their leader and the hiding place of weapons. Our division stated that in any case, lower-ranked members of public authority of a foreign state do not enjoy functional immunity in national criminal proceedings pertaining to war crimes. Furthermore, in February 2024, our division clarified that the general functional immunity of public officials does not apply to crimes under international law, regardless of the status and rank of the perpetrator. We noted that functional immunity for foreign officials is excluded in the case of crimes against international criminal law and is an indisputable part of customary international law. And some time ago, or sometimes later, the Cour de Cassation, the French Cour de Cassation, confirmed our standpoint. With regard to Syria, there are numerous cases against members of terrorist organizations, such as the Islamic State, who are charged with war crimes, crimes against humanity, and the crime of membership of a foreign terrorist organization. In addition, there have been and are trials of state-orchestrated crimes in Syria. For example, before Koblenz Higher Regional Court, the trial for state-sponsored torture in Al-Khatib detention facility in Damascus, and the Frankfurt trial against a doctor in a military hospital in Syria. Also to mention another trial concerned crimes committed in Gambia. In November 2023, Celle Higher Regional Court convicted the accused, a driver of the Junglers, a paramilitary unit set up by the then President Jaja Jammeh, of inter alia the crime against humanity of murder, and imposed a life sentence. The accused appealed the decision. We rejected the appeal, and as a consequence, the decision is final. To summarize, German prosecution based on the Domestic Code of Crimes against International Law covers many different countries. The Federal Court of Justice and the German higher regional courts, as I said, as fact-finding instance, as first instance, made decisions, and I have to estimate, in relation to approximately 40 cases in total, with more than 120 decisions of the Federal Court of Justice. And the Federal Public Prosecutor General of Germany is very active in this field and conducted and conducts in total more than 300 investigation proceedings based on international criminal law. And to admit, I was surprised of this number, but it's a lot. So we are as a result, we are very active in international criminal law. Thank you.
Thank you very much. And then as pre-announced, I would like to ask Mr. Thony, who is in a very unique position, because you can, one, tell us about how the situation in France is, but two, from the work of your institute, I think you have a good overview of how it stands sort of worldwide. Thank you.
Thanks, Philipp. Yes, let me talk a little bit first about the situation in France, although Leila talked about it much more eloquently than I could even do it. But it's a good introduction for me. You talked about the Touvier case, about the Barbie case, which actually occurred more than 30 years after the Second World War. And when we talk about the time for justice, and I was thinking of that when I saw that one of the symbols in this room is time flying. Sometimes justice takes a lot of time, but deserves to be done. It took a lot of time for France to acknowledge its own accountability during Second World War. France was not only about resistance, about all the beautiful stories and images we know about it, but it was also about collaboration. It was also about participating in the atrocities committed by the Nazis. And apart from what happened with the Comité d'Épuration right after Second World War, they took a lot of time to begin to think seriously about it. You know, I'm from Alsace origin, so my grandfather was born German at the end of the 90s, and he fled Alsace in 1911 because he didn't want to be, he was 21, he didn't want to be enrolled in a German army. There was still a very strong French sense in Alsace at that time, and he then combated for the French army and etc. And when I read, and you know that Alsatians during Second World War, when were enrolled in the German army, we were calling them les malgré nous. They were enrolled even against their wish, and since they were not considered as reliable, they were sent on the front in the east, but some of them even in the SS divisions. And it is said that this SS division, which came back urgently from the south of France to go on the front a few days after the debarkation, after D-Day, stopped in a village, Oradour-sur-Glane, took hostage all the population, more than 600 persons, and they put it in the church, and they burned them alive. There were 600 dead, and this village is still a memorial. You can visit it, and I would recommend that you do it when you go to France. It shows what kind of atrocities can be done in that context. And it is said that there were Alsatians in this SS division. And I came back to Alsace as a prosecutor general virtually 100 years after my grandfather left Alsace. And this story of the Malgré nous was a taboo. You couldn't talk to people about it. You couldn't talk about their involvement. Once again, this is to illustrate the fact that it took a lot of time to France to confront the past, to confront the history. And I think that the Touvier case, first the Touvier case, then the Barbie, and then later the Papon case were triggers and allowed us to, although Barbie was not a French citizen, but Touvier and Papon were, and Papon even became, during the 70s, Minister for Budget in France, before being convicted for complicity of crimes against humanity in 98, if I remember. It was a trigger that allowed French people to begin to talk about it, to begin to act about it. And as a matter of fact, we began to see all the legislation about crimes against humanity, even long before the Rome Statutes, were introduced in French law at the beginning of the 90s. So this is the history. It took time, but French came up to speed in this respect. And now things have completely changed. A lot of things have been put in place, not only the legal infrastructure, but also the the institutions. There is now a specialized structure at the Paris Prosecution Office, which is the pole on crimes against humanity, with a number of specialized prosecutors in it. There are also 3 investigative judges at the Court of Paris exclusively dedicated to atrocity crimes. Paris has an exclusive jurisdiction for that kind of crimes, and they are also supported by the very strong law enforcement office, the OCLCH. Central Office for Crimes Against Humanity, which is directed by the Gendarmerie, but actually gathers law enforcement officers from various law enforcement agencies who are really keenly specialized in these matters. So we have built up this specialization in Paris, which helps the French judiciary and the French law enforcement to be really in a position to do the job, I would say. Today, for example, we have 170 ongoing investigations on international crimes, covering more than 30 countries, including, of course, Rwanda, Syria, Ukraine, but also Israel, Palestine, and Liberia. We have, of course, a number of cases which have drawn some evolution of case law at national level, but also at international level. So this is what the situation is in France. So the question is, what can we learn from the experience at national level? We can learn a number of things. First is that developing a national systems allow first to put the international law into practical judicial practice. This is very important, because the practical judicial practice allows also to elaborate a case law, to build up a vision about these crimes. Second is that it allows national systems to pave the way for evolution of the international criminal justice system, and to give new ideas, new initiatives. Sometimes countries in the world, I'm talking here of France, but it's true also elsewhere, provided with some legal innovations which allowed or which may be seen as an example for the ICC, for example, but for international tribunals generally, to face some of the challenges that they are facing. Of course, there is this case law, for example, on immunities, and what has been done in Germany, but also in France, to develop a concept on humanities, in particular on functional immunities, is something that can help the ICC to develop its own framework. It's true also for victim participation. I think this is a key issue for the ICC, and it could be drawn from what has been developed in countries, especially in civil law countries, where the role of victims in the trial is much more important. To find new ways to address the issue of the participation in victims in international cases. And last, for example, the issue of trials in absentia, which is really the problem in international criminal justice. We have talked yesterday about the residual mechanisms, which is residual but does not end because some of the accused are missing. We have in civil countries the possibility to try in absentia with very strict legal safeguards, and maybe this could be seen as an example to follow. It does not hamper any fundamental rights of the accused, because whenever they are arrested they can ask for the trial to be completely redone from scratch, and this could serve as an example. So this is what a national system can bring to the international apparatus and to try to move forward in terms of concept, in terms of activities. What is done in France, and you mentioned the fact from Siracusa we see what's happening elsewhere. It's true that the Siracusa Institute has always been not only an observer, but full participant in the development of international criminal law, thanks to my predecessor, Professor Sherif Bassiouni, that you mentioned. The Siracusa Institute, I have to tell you about this story. Sylvia knows it by heart, but you and Piotr as well, but some don't know about it. The Siracusa Institute was established in 1972 by the International Association of Penal Law, which I'm happy and privileged to serve as Executive Vice President. This International Association of Penal Law was born in 1924, a few years after Second World War, and it held its first Congress in 1926, and the topic was 1926. Should we create an international criminal court? 1926. I love to repeat this story because we are talking of time for justice. It took 74 years to do it, and actually, Sherif Bassiouni was the chairman of the drafting committee of the Rome Statutes, and some of the drafts were elaborated in Siracusa, isn't it, Sylvia? I say that because we have a case about that. She said, no, the first draft was never drafted in Siracusa. That's not true. I pretend it is, so it's enough. And actually, this is what Sherif says, and I would never question what Sherif can say about that. So the Institute has been, I say that the Institute has been all along the way an actor of the international situation. It has also drafted the Siracusa guidelines on International Commission of Inquiries, and the Convention on Torture were also drafted in Siracusa. So we have a history of participation in international criminal law, and we continue to observe the situation and to take part of it. As such, what we see is a source of optimism, whereas at the end of the 90s, at the time of the creation of the ICC, of course, there was no complementarity because there was no ICC, but there were few examples also, except from the Yugoslavia and Rwanda tribunals, where countries were exercising jurisdiction on international crimes. Since then, so many things have happened. In Europe, of course, with Germany, but also we can cite Sweden, Belgium. Belgium was the first country to develop this idea of international, universal jurisdiction. It's not only in Europe, Latin America. You will speak about what is being done in Colombia, which is very courageous and which probably will set an example also. But before that, we have talked about it yesterday, Argentina also. In Africa also, a number of mechanisms have been put together in the Extraordinary African Chamber in Senegal, the Central African Republic Special Chambers, and I could cite a number of other examples. So what we see is really a very interesting development. Doesn't mean that complementarity is a reality today. There are so many things to do. Maybe we'll come back, because I've talked too much, on what are the challenges that we continue to have today. The situation is not completely set. I'll be happy to develop at a later stage. Thank you.
Oh, yes, we can come back to that. I would be very happy to, and we can also then combine those two other fields if we are really running out of time. However, I would first of all like to hear from Professor Urueña, because I'm very much interested in the Colombian case, and you have been very much involved with this and opposed to what we mostly talked about so far, universal jurisdiction. This is not a universal jurisdiction situation. It's a more traditional transitional justice context. So I'm very curious to hear what you have to say.
Well, thanks, Anne. So it's quite an honor to be here, and I want to thank the organizers and the Academy for inviting me. And of course, as Leila was saying before, so it's quite humbling to be here. So yesterday I arrived here, and room 600, and I was taking a picture. It was an amazing feeling, It's wonderful. And then, so last week I was in Bogota, the Special Jurisdiction for Peace, and they were notifying the first two big decisions, And then, so I was there, and then I am here, and then, so it really does require a lot of intellectual heavy lifting to think that these two things are part of the same story. And say, it's not self-evident. So one needs to think a lot. One needs a lot of tools, of intellectual tools, to think that, so this very concrete process with these very specific dimensions back in Colombia somehow are part of this same narrative, which I think they are. But it's not self-evident. So that's how I started thinking. So I started thinking, so this is amazing that I'm here, but on the other hand, what is it that we're doing when we do this? What is it that we're doing when we tell this story, that these two things, particularly when we're talking about domestic experiences, which is the panel, are part of the same story? And what I'll do, because I am a compliant panelist, I am going to answer the actual question. So because that's what I got what I got thinking about, and then so how is it? So what kind of tools do we use to tell that story? In the connection between the domestic and the international. So what is it that we do? And particularly, what is it that domestic experiences are supposed to do in that context? I'm going to say 4 things about that. I'm going to be brief in that context because I want to move to education, because I think education is key in this conversation. So that's why I'm going to be brief. So 4 things. So what is it that we're doing? What is it that domestic experiences do? They do 4 things. So they perform an epistemic role. They define actors. They define a context. So they create a particular context, and domestic experiences are performed through institutional forms. So there's this institutional dimension that we seem to constantly forget. How is it that these domestic institutions come to life? So that's kind of the first thing that I'm going to say very briefly. So about the epistemic dimension. So it's very interesting, and that's kind of how I got to think about this. So it's very interesting because domestic experiences, they perform this role, so domestic international criminal justice experiences, if you know what I mean. They perform this very interesting role in terms of translating. So it's a very tough thing to translate a crime in Colombia committed in the context of the war on drugs and the armed conflict, to translate it to make it sound as something similar to what the Nazis did here. So it requires a lot of work, but that's the tradition. That's the tradition. Somehow, these domestic experiences need to fit into this narrative of basically the room in which we are in. And that so that's an epistemic role. That's an in the sense of defining both scales and time, and time frames. And then domestic institutions need to do that very often, and they need to do it, of course, implicitly, because they are applying the law, but they apply the law by defining these sort of skills. And they do it not only in terms of skills, not only in terms of time, but in terms of defining processes. I was very interested, or it spoke a lot to me, what Professor Jain was saying before in terms of slow violence. Because this idea of slow violence is something that one sees domestic institutions taking up, socio-economic processes that end up becoming crimes against humanity or even genocide. But these are processes that, of course, the epistemic role of domestic courts, they capture easily. Whereas international courts have a harder time because they think of these events as discrete events unconnected one with the other, because as lawyers, we're very, very bad, as international lawyers particularly, we're very, very bad at thinking about change. We think that, so we have one thing, and that thing is supposed to have been here all the time. We have all tried to teach how is it that something becomes customary law or something like that. So it's hard. It's hard to think. So what is the precise moment in which, practice and opinion becomes the rule? So this kind of idea, this kind of process, and in particular with regards to violence, that's the case. So how is it that we think about scale? How is it that we think about time? And particularly, how is it that we think about processes? And when is a process, it stops being a process and becomes an event? That's an epistemic issue. And that epistemic issue, domestic processes do it, domestic justice processes do it all the time. The second dimension is actors. So who are the players? So for instance, corporate players are notably absent from the international realm. Whereas in domestic contexts, they tend to be more present, or they tend to be brought more often to the conversation. Why? Because at the domestic level, it's clearer that corporate actors play a key role in creating the conditions of possibility of atrocities. Whereas at the domestic level, of course, we have, at the international level, we have this tension in terms of state-centric processes of adjudication. So the domestic processes, they define a certain way of actors, and that's why they perform this role in those terms. The third one is context. So when looked at from the international to the domestic, the national is a context. You need to consider the context where crimes occur. But of course, we know that context. What is the context? People who do history, and there's this interesting conversation of historians of international law with normal historians, and then so what's the context of a legal utterance? How do you think about context? So those folks have that conversation there, but I think that conversation is also very relevant for our purposes. How do we define context? So people who do development work, they know that it's an open signifier, that you're all the time redefining context through the policy that you're implementing. So domestic initiatives of justice, for instance, like the special jurisdiction for peace, they define what the context is. So they are, let's say, the authoritative voice that says, this is the context, and hence this is the context that international institutions are going to take over, or that they should think through. So that's part of the epistemic role, but it's a very particular epistemic role in the sense of defining what is it that it's reality when like a doctrine like complementarity takes place. And that context also very interestingly also includes the legal ecosystem where domestic initiatives occur. So, for instance, are domestic initiatives like of transitional justice, for instance, Leila was talking about the US. That's fascinating. So, is that part, so in the US, it's clear that that's part of a wider constitutional conversation, let's say, and there's the Supreme Court and all that. In the Colombian case, there was a huge conversation whether the special jurisdiction for peace, the decisions of the special jurisdiction for peace would be subject to the revision of the Constitutional Court or not. So whether the ecosystem of a transitional justice initiative is the legal ecosystem is the constitutional ecosystem of the state, the domestic constitutional ecosystem, or whether it's something separate, independent. And that also appears with regional human rights regimes. So we tend to think of ICL as, basically self-contained, independent. We have, of course, we have conversations, so on and so forth, but you're technically independent. But when looked at from the bottom up, that's absolutely not the case. It's constant interaction. And for instance, in Latin America, the constant interaction of international criminal law with the case law of the Inter-American Court of Human Rights, of course, it's key. Regarding amnesties, of course, one is an expert on that. Regarding amnesties, what's the standard that should be applied? How do you prioritize certain cases? So there are different standards, and that's the overall ecosystem. And let me just finish up with domestic institutions of justice as actual organizations. So they are courts, they are lawyers, they are initiatives for justice, but they are organizations in the sense that they have a staff, you have to fund them, and they work with a mandate, and then there is this decoupling of the mandate and the powers. So, like you have all the same issues that you have with a traditional organization, be that a university, a private club, or an initiative of domestic justice. And that triggers a lot of very interesting issues in terms of how do we define what is it that we do when we tell that these two levels are part of the same narrative. Why? Because there is this tendency of isomorphism in the sense of domestic initiatives should somehow look like international initiatives to be acceptable, that the form, regardless of the actual working, but the form have to, they have to look more or less similar. It has to be, like a court like this, and people talking like that, and a kind of expert, and therefore you bring over the experts who teach how is it that the form should work. People who do organizational work in other fields of the law, they have discovered that. For instance, with statistics institutions. Census and statistic institutions look very similar all around the world. And that's very funny because they are designed in a particular way. So how is it that the form of international justice travels? The diffusion of the form. And hence, how is it that we staff whether, where do we put the experts? How do we think about participation of victims? All these kind of things are human rights issues, are international criminal law issues, but they are issues of organizational structure. Yesterday we were hearing about the residual mechanism. So that's exactly it. So that's really what's happening there. It's an institution that needs to take care of a number of matters that is left over by other institutions. And you have all the issues of archives, of, I guess, labor, all these kind of things. And that's crucial. And I think we're not thinking that much about the connection between these two kind of things as an organizational matter. I'll leave it at that, and then we can talk more. Thank you.
Thank you very much for very interesting points indeed, a connection that we should not forget. But looking at the time, we'll soon have to start answering questions. So maybe I can ask you, Mr. Thony, to talk a little about education, as paraphrased before we hand it back to the professors to hear what they say. Thank you.
Thank you very much. Yes, clearly training and education is key to all this. I mean, international criminal law, as you know better than I do, is something very technical, very difficult, and you cannot exercise national jurisdiction if you don't have specialized people who can talk or decide on the issues like genocide, as you mentioned rightly, Bill. Other than talking about generality or having their own views about it, all these international core crimes are very, very technical, and the lack of training and the lack of education on all these issues is across the board. It's not specific to developing countries or elsewhere. It's all over the place. And I know from their experience in France, it's also an issue. I've been, as you mentioned, the director of the École Nationale de la Magistrature, the French Judicial Institute, and you know that in France, to become a judge, you pass a competitive examination, and then you have a 3-year training and education before becoming a judge or a prosecutor. And in 3 years seems to be very long, but you have so much to learn to become a judge. I'm surprised that in another country you are appointed as a judge, you have never exercised this, and suddenly you know how to write a judgment, you know how to hear a witness, you know how to adjudicate a case, to place a sanction. It is something that you learn like every job. And the difficulty is that you have so many things to learn to become a judge that it's true that you wouldn't think at international criminal law and international crimes as an issue that a young judge should be fully aware of. So there is no way that we can include that kind of teaching in initial training. But we should do it much more at continuing legal education stage. And in France, like in many other countries, this is a mandatory thing to do for judges and prosecutors. What strikes me also is that when we do a lot of training for judges and prosecution and mutual legal assistance, extradition, and all sorts of things, we forget that they're all based on international criminal law. And we teach them on how to draft a letter rogatory or an international mutual legal assistance request without teaching them about why there is a reciprocity issue, why there is immunities, why there is, etc., etc. And one of the result of my experience is that we should begin with international criminal law, and we have in Siracusa a course for prosecutors that we do with the International Association for Prosecutors on mutual legal assistance, international cooperation, and transnational crime. And we always begin with, under the supervision of the chairman of the academic board of the institute, Professor Bill Shabazz, we begin with the course on international criminal law and on international criminal justice, because I think it's the basis for everything. Once again, this need exists everywhere, and we will not be in a position to implement fully complementarity if we don't begin to train those who will exercise national jurisdiction on this. And this is also what the Siracusa Institute tries to do through a number of projects. Maybe we'll talk about it when we talk about operationalizing.
We are running indeed a bit low on time, but we're trying to get everything in. Thank you very much. Would you like to add something on if you'd like to? Because I know that you would like.
On education? Well, one of the things I think you've heard from all the panelists is institutions matter. So one of the institutions, and they matter for accountability. So one of the institutions we had in the United States was the Office of Global Criminal Justice. We had an ambassador for war crimes. We had actually a focus on accountability, not in the United States, but externally. That institution was just eliminated by the current presidential regime. So what does that mean? Students and professionals want jobs, and a huge cadre of young law students that might have gone to work for the Office of Global Criminal Justice that had as its focus the prevention, not just the punishment. There's a question about punishment in here, but prevention is really a key part of atrocity law and policy. And so we've just lost a major institution. So as an educator, when I'm trying to educate students as to why they should study international criminal law, I do not limit it to core crimes, because the crimes that are prosecuted in our country are prosecuted by our federal courts and federal prosecutors. I think it's the same in Germany. And so I teach terrorism, I teach drug trafficking, I teach all the transnational crimes in addition to the core crimes to show that these are not isolated, because let's face it, whenever we have core crimes, we also have financial crimes, because corruption is always endemic in a regime that's willing to commit atrocity crimes. So teaching about the Convention for the Transnational Organized Crime, the Corruption Convention, the drug trafficking treaties, I think that's actually a way to pull people into the field. They can understand basic principles of jurisdiction, universality, nationality, etc. They understand the fuller scope of transnational and international crime. And I think the siloing off of the core crimes from the transnational crimes is actually an intellectual and practical mistake. So I teach both, and that does pull my students in because they can still go work for the federal government and prosecute drug trafficking or plenty of transnational crimes, even if we've eliminated the Office of Global Criminal Justice, which I hope one day will come back, because I think the core crimes are not isolated. They don't happen in a vacuum. They happen with other bad stuff that's going on, especially terrorism, trafficking, corruption. We see them all together. So that's sort of my takeaway in terms of a very practical approach to trying to get people to understand the core principles, jurisdiction, application of the law, the complexity of international crimes, and prevention of international crimes.
Thank you. And then, because we are really running low on time, I would hand the word over to you, Professor Urueña.
All right, yeah, so thanks. So this, I actually do the same thing. So that's really, so that's a really good idea, and that's really the way, because we're also training people who will need jobs. So that's, and that's something that we need to consider always. Yeah, so it's funny because I do exactly the same thing. So I think that, I mean, what Leila said.
I need my job.
Exactly. So I think I think what was mentioned before in terms of what happens within the university, I'm not going to say more about that because you said it brilliantly. Perhaps what I would be more interested now is, so how do we think international criminal law education outside of the university, which is, I think, fundamentally important. So, and there are two levels to that. So on the one hand is, so how do we train the experts, like high-level experts, and then on the other hand, how do we train people who are not going to become high-level experts, but who still need an understanding of international criminal law for their own work in terms of activism, for their own work in terms of academia, or their own work in terms of doing perhaps other kind of law, human rights, gender, but they need an understanding of international criminal law. So I think those are two different audiences. So in the sense we have the intramural university target, so that's one thing. Then on the other hand, we have the extra university target, but that extra university target is the high level, how do we train the prosecutors of the future? Let's say very high level, how do you provide for them? And then on the other hand, we have all these conversations, Professor Jerry was saying before, so this is part of the conversation. Everyone's talking about this. So that's an audience. We need to somehow figure out ways to convey that message. So those are different audiences in that context. And to make it a bit more complex, we have those audiences both in the global north and the global south. So, and that means that it's an important conversation because, as you know, scholarship in international law, so the theory has traditionally come from the global north and the cases come from the global south. So, and then the question is whether there is theory or there is doctrine that tends to develop from the global south bottom up, which is part of the conversation. And how do we train people on that? So universities, I'm not going to talk about that. Perhaps in terms of the more expert dimension, it was brilliantly assessed before, so I'm not going to dwell more on that. I think I'm perhaps on the latter audience. So how is it that we train these other kinds of people? And I think digital there is key. So I think we need to develop more initiatives in terms of reaching people where they are through a number of tools. We have developed at Los Andes a number of massive online courses which are designed to introduce people in their language to international criminal law, particularly in terms of gender. So gender persecution, that was one of the courses. But it was a particular challenge because a lot of the stuff of the literature that we have to teach is extremely complicated. It's very hard to teach. So it really requires a very steep the curve of understanding that we're not going to get at that level. So I think that a key question in terms of teaching is, of course, what was said before in terms of judges and in terms of intra-university, but outside of the university, I think that we really need materials that are designed for people who use international criminal law, but who are not going to become experts on international criminal law. And that's not a bad thing. It's a good thing. And we need to cater to that audience, let's say. And I'll leave it at that.
Thank you very much, and very illuminating indeed. I would now like to move on to the third part, and we have some questions already that have been coming in, and some can be grouped into categories, and we can maybe start with the first quick one for Judge Hohoff. Can you say anything about whether you believe that the German system as it is in place now allows for prosecutors to be selective because they target Syrian cases but not US soldiers, for example?
That's a difficult question, in particular for a judge, because it's the policy of the federal public prosecutor of Germany who decides who he wants to charge. And it's always a question, we don't have trials in absence. So we always need the accused or the accused people, otherwise there won't be any trial. And as I know, the public prosecutor of Germany, he charges or he prosecutes only cases with a relation or a connection to Germany. That meaning that the accused lives in Germany or some other situations. But in general, the public prosecutor is of the view that only these cases should be prosecuted and should be on trial in Germany.
Thank you. I'm gonna group a few. The mention of immunity has sparked a lot of responses, and what people are especially interested in is whether the panelists believe that immunity is not as much of a problem in a democratic system. The example of Spain was mentioned a number of times, or the question phrased in a different way, why does Spain seem like a relatively robust society, although they maybe have a bit of an impunity problem? Then we have something here about the Crimes Against Humanity Treaty. I'll just read it out from Nuremberg to Pinochet. The treaty is visionary, but does its prosecution focus, risk silencing memory, truth, and systemic accountability?
That's the question I wanted. Well, because actually I think the other panelists have something to say about this too, right? Especially in Colombia. So again, the question, very thoughtful question from online maybe, or maybe in the room, it sort of pits prosecution versus, I believe it was memory, truth, and systemic accountability. You know, a couple of things. One is, just without going into too much detail, the second core, or maybe the first core pillar of the draft treaty is prevention. It's not all about punishment. And I think we could have a long conversation, not on this panel, but another time, about the importance of atrocity prevention. And many of you have heard me talk about the atrocity cascade and how moving up the inflection point where you can actually intervene using the criminal law is critical for atrocity prevention, so you don't get mass atrocities and genocidal outbreaks. But the other thing that's interesting about the question is it lists memory, truth, and systemic accountability. You know, memory and truth are not the same thing, right? Memory is inherently a flawed personal recollection of what happens. It's not antithetical at all to a criminal prosecution. A trial can be a way to create a narrative. That was certainly true in the international criminal tribunals and at the ICC. It was certainly true in the Touvier case, where the partie civile came forward and they told what happened and they could remember it. Truth is another issue, right? Because personal narratives may have very, very different elements of truth, because what I remember may not be the same as what you remember. Truth commissions, again, are not prohibited by any move to accountability or prosecution. They can operate completely in tandem. So there's no opposition between a treaty on prevention and punishment of crimes against humanity and truth. And in fact, in many epistemic systems, truth is always second to nonviolence, and nonviolence is always the first principle, because there's an awful lot of violence that's perpetrated in the name of truth, because my truth may be different than your truth. So I would say that's not one that I would adhere to. And that goes to systemic accountability. It's really hard to envisage systemic accountability systems without individual criminal responsibility at some level, at some time. And what I think about is going back to my example of the United States, when President Obama said, he had Eric Holder, our Attorney General, look at the torture cases and said, you know what, we're not going to do that because it's complicated, we just need to move on. And in fact, we never got systemic accountability, we never got Guantanamo Bay closed, and so when it's in the hand of a new administration that would not only like to reuse some of the principles that were developed in the early 2000s, but expand them and start rendering people to other Latin American countries or elsewhere in the world, not only did we have a complete absence of systemic accountability, but now we have an expansion of impunity. And so I kind of maintain that the empirical evidence we have thus far shows that at some point justice is a core element of atrocity prevention. Without justice, without some sort of individual accountability, you can't get to the question of systemic accountability, because the impunity beast just grows and grows. That's my personal view, and I think it's supported by the empirical evidence, and it's certainly supported by my own personal lived experience in my own country.
Regarding the treaty, I agree completely. So I think that's so put like that in the sense of whether certain prosecutions prevent memory or truth. I think that's a false dilemma, and I think there are many examples in which there are ways in which one can think through these kind of challenges. But I think so. I want to mention two things that maybe helps us think through these kind of challenges. So the first one is the scale of time, as we were saying before. So it's really, there's a huge challenge in terms of, all right, punishment, accountability is immediate, whereas memory, truth tends to have longer scales of time. And that's a deep conflict. So how is it that you think about time? And let us not get involved with, the issue of, systemic violence, for instance, with the climate emergency, which then we think in terms of planetary scales of time. So the tension between, the tension of the time scales of accountability and truth or memory, that tension allows, so it's not that we're going to solve it, but if we think about it in terms of attention, in terms of scale of time, it allows us to think better how to be more fair, or fairer, how do you say in English? Fairer. Like to deliver a more fair answer, let's say, to people, so for people's demands. So that's one thing. And the second thing is, so what kind of role can a system such as this, either the international prosecutions or domestic initiatives of justice, what do they do in terms of, as Professor Sadat was saying before, in terms of creating narratives? And that's something that I've been talking a lot with my colleagues at the Special Jurisdiction for Peace, and what I tell them is, so that court really works like a truth tracking device. It's not that it creates truths, but it kind of tries to track the truth, knowing that it's never going to be able to achieve it. So it's a way of kind of a weird epistemic stance, but I think that's what they do. In a way, they try to track the truth, and by doing that, so it's a device, and they use a whole set of tools to do that. Some of those tools are other institutions, like the Truth Commission, but also part of those institutions are also the prosecutors and civil society reports and so on and so forth. But it's a way of tracking the truth without accepting that there's a single truth in that sense. But of course, that's going to create a pushback, both in terms of the scale of time and in terms of so because it's truth tracking is never going to be final, and there's going to be a pushback. And that pushback is going to end up most likely before a court, either a constitutional, for instance, in the Colombian case, either before the Constitutional Court or before the Inter-American Court of Human Rights, where a victim is going to say, look, this is not working for me. So this, I don't have access to justice in this process of truth and reconciliation. So something was lost for me, and I'm not getting what I deserve. So at a given moment, that truth tracking process kind of has to stop, and someone has to say, you know, the buck stops here, and then the process starts again. But so there's this process of truth tracking, stop, and then truth tracking again, and I guess that's never ending. But I think that's kind of the connection in those terms, because people are going to reject a particular way of framing the issue, and someone is going to have to say, yes, you're right, in the sense of this whole, for instance, the Colombian case, this whole transitional justice process is in breach of the Inter-American standards, or no, we understand what you're saying, but you know, there are these reasons, there is this case law, and hence this is good. That would be kind of the tension there.
Thank you very much. We have a question in the room, which I would like to just jump to.
Yeah. So, good morning, and thank you very much for this forum. I really appreciate your point of view based on your own domestic experience. For me, it's really important to have these high-level speakers here, and really, for me. I was thinking just about the previous step for a genocide, as well as during the genocide, because I think it's really interesting. We had, for example, examples of arrest warrants, like in Spain with Augusto Pinochet, and other cases like, for example, France against Bashar al-Assad, as well as Argentina with Daniel Ortega. But what about now? We have, for example, internet. We can have direct images of what is happening. This is not suspicion. This is the real genocide. But I was thinking about the origin. Genocide is not something like popcorn. It's not something like happened like this. So we have like some details that show that something is going on. And things that you don't need to have studies in law or something like this. There are evidences that prove that there is something happening. It needs some time to take place and to escalate. And usually there is not only a single crime. Several times genocide is also, we have cultural genocide, ecocide, crimes against journalists, and so on and so on. We can see that in Russia and in other countries, like for example in Gaza, what is happening now. Almost 77 years since the Genocide Convention, and we can see what happened after. And I would like to know, what about the prevention of genocide? For example, we had Bosnia, when the authorities were trying to push this kind of division into the population, when they were encouraging violence between each part, or for example, the Rwanda genocide between Hutus and Tutsis and so on. My question is, first question, should the Genocide Convention be reviewed, or we can see that it was enough, this text? Or what about as well the difficulties of the domestic experiences regarding this international law, regarding what happened in Colombia, for example, with the indigenous communities? And the second question, once we have already genocide, what about the responsibility and accountability of the necessary accomplices? I mean, the states that decided to provide some kind of support, for example, direct support, selling arms, or providing some kind of logistic support, allowing that war criminal people crosses its territory, or the transport of staff for the army, or the states even that decided to remain silent because they have some kind of interest and they don't want to make this kind of confrontation with the states. And in case of this lack of accountability, the case of Serbia, for example, we have still people free that committed some kind of war crimes. Can we talk as well as about a failure of the system, and it's linked directly, for example, to the veto of the UN? I think that it's very complex to talk here in 5 minutes, but I think that it's really important to take into account other details, and thank you very much.
Well, thank you for the question. Would somebody on the panel like to say something? Shall we? That we can do, yes, that's a good idea.
Under 30 seconds. Okay, it's really nerve-wracking, but okay. If you look at, first of all, thank you for the presentation. I'm William Fortin. I'm a PhD researcher at Tilburg University. Okay, this is out of the way now. So when you look at UG cases or domestic persecution of international crimes, and I think we can understand it as an ecosystem, as something that doesn't exist only in those individual countries and they don't communicate to one another, and there's a shared narrative, and sometimes there's also pullback on one side and everything. But I was wondering, because recently we had, for instead, in the more formal aspect of it, the Ljubljana The Hague Convention, when it comes about cooperation for investigations and persecution. But then you also have the less formal, like the genocide network. And I think judges even have some kind of network where they can exchange information with colleagues when it comes to domestic persecutions of core crimes. But right now, with the rise of UG, it might look a bit as a side problem or a non-existing problem right now. But if they keep multiplying, there's a question of like who gets it first if there is a conflict between jurisdictions? Who can claim universal jurisdiction for the same case? So while we have an evolving, I would say almost organic system when it comes to persecuting international crimes at the domestic level, is there something in your opinion that is missing in the current system to allow maybe guiding principles like who has the, beyond the authority, who has the legitimacy to prosecute a case based on universal jurisdiction if more than one country say, well, I have the victim on my territory, or I have some kind of interest in that case, or none of them have nexus, but they want to have a go to it. Some cases will be, well, it's easy, they just have to be on the territory, but we already talk about trials in absentia that is an ongoing conversation. So is there something missing in the system, guiding principles, another treaty, why not? Like something that would help us to maybe put a little bit more order in this idea of the rise of universal jurisdiction, and maybe put a little bit more everyone into line when it comes to cooperation between domestic jurisdictions. Thank you.
Thank you very much. Then we jump into here because we have no more. Please.
So that's a lot of questions. So let me take the in a way, the easier one first, which is the conflict of jurisdiction question, William. It's true. We would, frankly, we'd love to live in a world where states are fighting to get hold of perpetrators of atrocity crimes. I actually don't really see that's happening. So I think this is a hypothetical situation. But you're right. Practically speaking, if national systems were hyper-empowered to do this and to expand their jurisdiction extraterritorially, as opposed to limit it, for example, to individuals found on their territory, you could get this competition. This has come up, actually, in the drafting of the Crimes Against Humanity Treaty. We had in our draft competing extradition requests and a set of hierarchies, which is based on the UN Model Extradition Treaty. So that is one possibility. It also came up in the Hague-Ljubljana negotiations, which were referenced. Now, cascading jurisdiction, however, the problem is that you can get an impunity problem, because if you give priority always to the territorial state, and you know that the crimes are going to be committed while the regime in power might be perpetrating, right, continuing to perpetrate the crimes, and you give priority to the territorial state, you're going to basically gut the utility of universal jurisdiction as a possibility for atrocity prevention. And we are seeing sort of, that segues into the second question, which is that often, or the first question, which is that often when you have an atrocity situation, you will have both victims and non-governmental organizations and states looking at ways to extend their jurisdiction extraterritorially in order to reach that situation. So with respect to the war in Ukraine, with respect to the war in Gaza, with respect to Sudan, with respect to Myanmar, a case was filed in Argentina, right, under universal jurisdiction. There is an effort to reach those situations, especially if access at the international level is blocked, using universal jurisdiction. And if you had priorities of jurisdiction, you would essentially eviscerate the regime that we're trying to use to prevent, remember, Lilliputians were trying to tie down Gulliver. So I suspect there will be a proposal to put in possibly to the treaty ideas about maybe guidelines. I don't know. There is a state that has proposed that there should be a priority of jurisdictions, and that's not been felt civil society is not very happy with that because that seems to be promoting impunity. In the international sense, I should also point out that, we are using universal jurisdiction often because the international route is blocked. So Syria, we were totally blocked with Syria. We had to stand up the IIIM in order to, I see Michelle Jarvis, because we couldn't get a Security Council referral to the International Criminal Court. So thank goodness that France and Germany are looking at these huge refugee populations on their territory and are willing to take these cases. So I hope that some of that, I might just one coda, and then I want to let René jump in on here. In terms of the Global South, you mentioned, is the theory coming from the Global South? I think, as opposed to just the Global North, one of the things that I try to do in my speaking, and this does come up in one of the online questions, is as the new Treaty on Crimes Against Humanity gets negotiated, I think we're seeing a lot of push to include something like slave trade, to include environmental crimes, to include crimes that are of preoccupation to other populations, because it is understood that the treaty, even though anchored in the Nuremberg paradigm, has to expand beyond that so that it takes into account really the needs of modern society and of people all over the planet who feel victimized either by environmental harm or by the slave trade or by other harms that maybe we weren't thinking so much about in 1998. And so I do see a lot of great ideas coming from Global South countries in terms of infusing into this new process because it is open to all UN member states.
Thank you very much. We have about 5 minutes left. If there is no further questions in the... Yes, please. I'm sorry.
Sorry, no, very briefly, literally. So about the domestic experiences, about genocide, because there was a direct question regarding Colombia. So in Colombia, the charges have not been genocide. On the one hand, and then when a particular case, the Unión Patriótica case, appeared before the Inter-American Court of Human Rights, and one of the charges of the victims was that it was a political genocide, the Inter-American Court in terms said, and that was one of the arguments that actually was said in the prior panel is, we can find state responsibility of serious breaches of human rights without having to assess the issue of genocide. And then very briefly regarding the networks, so I think, this question of networks is very interesting, and I think that's like an untapped possibility for us as international criminal lawyers. So if you think, for instance, in competition law, there's the International Competition Network, which is informal, but their decisions is really a very important dimension of what national competition authorities do. And then we, in banking and finance, we have the Basel Committee. And the Basel Committee is an informal network of central bankers, but they decide the basic standard of capital requirements for banks. So it couldn't be more important. It is not a treaty, it is not an institution, but it is a network. So this kind of informal networks, I think there's a huge opportunity to formalize certain these kind of networks that would allow for this kind of conversations that go out, that are outside of academia, but not formal cooperation. And I think, again, what is the form? What is the institution? I think that this form of the ICN or the Basel Committee is something that we might be interested in looking at in those terms, so following up on the question of networks.
Thank you very much. Is this another question? You have 2 minutes, and that includes the answer, please.
I try to be very succinct. I also think this sort of just thinks a bit more about some question that was already asked about sort of the selective enforcement when it comes to international criminal law. But my question goes a little bit in a different direction, and I want to ask, since the role of institutions was already mentioned multiple times in this discussion, so I want to ask specifically about the role not of an independent judiciary, but also about an independent prosecution office, because there have been two recent examples. If we look at the prosecution of international crimes, so if we look, for instance, at Brazil and South Africa, we can see they have independent prosecution officers, and this already plays an important role when we look at Vladimir Putin, who would really like to attend, obviously, the BRICS conventions in these two countries, but he doesn't do it because he is scared, although he is good friends with the leading politicians there, that their independent prosecution officers would actually work against him. In Germany, meanwhile, as also criticized by the Council of Europe numerous times, the Federal Prosecution Office is subordinated to the Minister of Justice. And so I would ask specifically to Ute Hohoff, do you see any problem with regard to equal distribution of justice, in particular when it comes to crimes that might be committed by soldiers of our political allies, and would you think that it would be necessary in Germany to also give more independence to the prosecution office with regards to, on the one hand, the Völkerstrafgesetzbuch, but also when it comes to the Rome Statute, so for example, extraditions, etc.?
That's a political question, I think, and to be honest, I think our system now works well. I don't see the necessity to change the position of the federal public prosecutor in Germany, but I can understand the arguments against his dependence on the ministry. I understand it, but I think with regard to the international crimes, it works well.
Okay, that is quite perfect, because we are 11 seconds before our scheduled end. Thank you very much. Thank you very much for everybody who was here. Thank you very, very much to our panelists. I thought this was a great discussion. And I was asked to tell you now that lunch will be ready outside, and bon appetit.